Well, I think we can make a start. Welcome to this meeting of the Planning Applications Committee. I'm Councillor James Husband, Chairman of the Committee. To my right, I'm joined by my fellow councillors, and it will be the five of us who will be making the decisions relating to the case on this evening's agenda. To my left, we are joined by council officers from the Planning Department. They will be presenting the case in front of us and also offering us their advice as well. Okay. Now, first of all, okay. I hope that's a bit better. Can everyone hear me now? Is that better? So the membership of the committee, Councillor Lowry has been appointed to the planning applications pool, enabling him to sit this evening, and Councillor Hargreaves is replacing Councillor Mackover, who I think on some agendas that might have been circulated earlier, Councillor Mackover's name might have appeared. But our membership is entirely in order. If I can just confirm, there are no apologies, are there, Holly, for absence? No, there are none. Good. Okay. If I can now ask, are there any declarations of interest? Roberto.
Non-pecuniary, but I have, as ward member for the ward, I have received representations from a number of people about it, but I remain, open-minded.
Yeah, and that's understood.
Yeah.
Yes, I think that's that's actually an other declaration. Wella, did you want to make a declaration?
No, Chair, I don't have.
Okay, all right.
Thank you.
I should just declare as an other declaration that I sat on the original planning committee that was minded to grant permission several years back before it was called in by the Mayor of London. So just I note that as for the record.
Chairman.
Yeah, Councillor Lowry.
As an other declaration, I know some of the people listed to speak as a local resident. I live nearby, so that's...
Okay, yep, that's understood. I think, again, that's an other declaration.
It is another yes, but
yep.
with regards to both your declarations,
yes.
Can you both confirm that you've still got an open mind tonight?
Yes.
Yes, both of you.
Councillor Lowry?
Yes.
Yes.
Okay,
good. Okay, thank you very much. Okay, so if we can now move on to, we've got one set of minutes to approve. These are the minutes that were held, the committee that was held on the 22nd of June. I think, Walla, you were actually at this committee as well. Can we agree that I sign those as a record? Thank you. Okay. In that case, we can now move on to the first and only item of business, which is the application at Haythrop College, 23 to 24 Kensington Square. And Cheryl Savarus, who's the case officer, is going to introduce this. So, Cheryl, when you're ready, please go ahead.
Thank you, Chairman, and good evening, councillors. Can I just check that everyone in the room can hear me clearly? That's great, thanks. So my presentation this evening forms three parts. I'll start by giving background to the application. I'll then move on to what the application proposes. And thirdly, I will be giving you updates to the assessments of the proposals since that committee report was published. Starting with the background then, planning permission was granted on the 17th of August 2020 for redevelopment of the site, principally as an extra care facility. The council supported that scheme and resolved to grant permission for it, but the Mayor of London directed refusal. That refusal decision was the subject of a public inquiry at appeal, and the planning permission was granted subject to conditions and a Section 106 legal agreement. Condition 1 of that planning permission decision notice imposes a time limit of 3 years to implement the permission. The time limit is absolute. There is no mechanism to extend the time limit for implementing the planning permission. None of the pre-commencement conditions and obligations that would enable implementation of the planning permission have been discharged over the last 3 years. Those conditions and obligations were agreed willingly by the applicant at the time, but they now consider that the way the planning permission is construed places an unnecessary practical and financial burden on them. Paragraphs 4.6 and 4.7 of the report sets out the applicant's explanation for why the planning permission has not been implemented. Whilst the applicant's reasons for what they have done or perhaps haven't done are stated in the report as background information, these are separate to the planning merits of the proposals, which are the subject of the committee's assessment this evening. To confirm, the planning permission has not been implemented and expires in less than 30 hours. The applicant wants to implement this planning permission, but time has run out to satisfy the pre-commencement conditions and Section 106 obligations ahead of implementation. The applicant wants to implement the planning permission without satisfying all the pre-commencement conditions attached to the planning permission and all the relevant pre-commencement Section 106 obligations, and without having to pay the community infrastructure levy in full upon commencement of the development. Hence why we have the current proposals. What the applicant seeks to do is to create a phased development by adding a planning condition to introduce a phasing plan which changes the permitted single-phase scheme into a two-phased scheme, amending existing conditions to reflect that proposed phasing, amending Section 106 obligations to also reflect that proposed phasing, and to create 2 chargeable developments for the purposes of a phased SIL liability for the new and additional floor space. The mechanisms to achieve such a phased development are a Section 73 application and a deed of variation to the Section 106 legal agreement. Section 73 of the Town and Country Planning Act enables applications for planning permission for the development of land without complying with conditions attached to a previous planning permission. It can be used to make a material amendment to a planning permission by varying or removing conditions associated with that planning permission. When a planning permission is granted under Section 73, it takes effect as a new independent planning permission to carry out the same development previously permitted, subject to new or amended conditions. Section 73 cannot be used to change the description of the development, nor can it be used to extend the time limit for implementing the planning permission. If this Section 73 application is granted this evening, it will expire at the same time as the original planning permission, in other words, by midnight tomorrow. If it's granted this evening in accordance with the recommendation, then the deed of variation to the Section 106 agreement can be completed tomorrow, thereby enabling the decision notice for the Section 73 planning permission to be issued tomorrow. The applicant then intends to implement the Section 73 permission during the course of tomorrow. And in implementing that permission, before its expiry at midnight tomorrow, it would be kept alive in perpetuity. So, moving on to the phasing proposal, the purpose of phasing is to divide the site into distinct parcels of land, and that allows conditions in Section 106 obligations to be discharged in relation to each parcel individually as it comes forward to be developed in a sequence. What it allows is for relevant triggers to be applied to ensure that the appropriate submissions are made at the right time for the council to control and manage how a development is built out. Phasing also allows payment of SIL liability to be staggered across separate chargeable developments. What I've got on screen here is the applicant's phasing proposal. The plans show demolition and refurbishment works, which is what you see on this slide, and then construction works. So to confirm, what you see on this slide is phase 1 outlined in the green boundary. I know members, you have a copy of this plan in your pack. the construction of Building 4 Community Hall, the green space adjacent to the building, and the site access from Southend. All of those works comprise Phase 1, and then Phase 2 is the remainder of the development. The applicant has also provided, as part of this phasing strategy, a programme. And so for Phase 1, this is a 25-week build programme for the community hall. Starting the phasing with the construction of the community hall is considered acceptable. The community hall doesn't rely on any other part of the development to justify it. In itself, it's a social and community use, which is acceptable in land use terms. And the design details that are required by recommended condition 5 would ensure that this building and its immediate surrounds would be acceptable. Moving then on to Phase 2 programme, this comprises the construction, or rather redevelopment of the rest of the site, which would take about a 5-year period, and this includes the deck overbuild construction, works to the north area of the site, and then works to the south area of the site, with overall completion expected by the end of 2029. I now want to draw your attention to the addendum report, which contains updates since the publication of the committee report, and these include agreement to the final draft deed of variation to the Section 106 agreement, and all necessary parties have signed this agreement apart from the council. Further consultee responses from the reconsultation have been received. And what that means is that all Phase 1 details that would otherwise be pre-commencement conditions have been satisfied, with the exception of Condition 20 relating to the Considerate Constructors Scheme, which requires the applicant to take action to comply with that requirement prior to starting any works on site. Amended conditions have also been drafted to confirm the Phase 1 details, which are considered acceptable, and a new condition, that's Condition 61, has been added to specify the phasing. 3 further objections have also been received to the application, the content of which is very similar to other objections that have been received earlier during the course of this application. So, in summary, the Section 73 application was not acceptable as submitted, and that feedback was given to the applicant. Paragraphs 4.30 to 4.34 of the report set out how the application was amended, supplemented with further information, and, being still deficient, was further revised and supplemented. Now that the revisions have been made and further information provided, the proposals do create an acceptable phase development and are considered acceptable overall. I want to draw your attention to the original planning permission that was granted following the public inquiry, because it is a material consideration of significant weight in the assessment of this Section 73 application. The planning inspector represents the Secretary of State, and significant weight does need to be given to their decision on that original planning permission. The courts have held, in summary, that a previous decision should be a powerful material consideration in any new determination. There is public interest in the consistency of decision-making, and the decision-maker now has to have a very good reason to depart from another decision-maker's reasoned, rational judgment, especially when the decision-maker is a planning inspector on behalf of the Secretary of State. The Section 73 application complies with the development plan and satisfies the statutory requirements for a conservation area and listed buildings. If granted this evening, the recommended conditions would secure compliance with the Phase 1 details that are considered acceptable, and it would require submission and approval of further details relating to Phase 2 before those Phase 2 works begin. The deed of variation to the Section 106 agreement would be completed tomorrow, and a new permission will exist to carry out the same development previously permitted, subject to the varied conditions. The applicant must implement then that Section 73 permission before its expiry at midnight tomorrow. And that concludes my presentation. Thank you.
Thank you very much indeed. So we have speakers this evening. So first of all, if we can hear from objectors, we have Michael Bach, Mr. Cook, and Mrs. Lyle Mannering. Perhaps you have up to 6 minutes shared between you. Whenever you're ready, and in whatever order, perhaps you would like to go ahead. Obviously, you're all local residents to the site. Michael, would you like to start?
No, I'm not going to start speaking. I'm going to tell you what we're going to do. That's
All right.
Mrs. Lyle Mannering is going to start,
Okay.
and she's going to take 3 minutes, and I'm going to wrap up, and that will be 3 minutes. And I do hope that we actually manage that within the 6 minutes, although 6 minutes isn't critical. So I'm going to hand over to Mrs. Lyle Mannering.
Very good. Thank you. So please go ahead when you're ready.
Good evening. Evidently, pressure has been brought to bear on planning to rush this matter through. The community needs faith in the process and believes the same rules apply to all and is not subject to behind-the-scenes manoeuvring. We also want consistency. And I will just interject that the planning inspector actually refused phasing, so if we're going to pay attention to what he said, we should pay attention to that too. The 2020 permission was wholly inimical to the Haythrop SDP, but was felt that benefits promised outweighed logistical and safety problems. Now the applicant is still urging those benefits when clearly no longer deliverable. It cannot build over the railway, costs have increased, potential returns have decreased. In its accounts to December 21, its interest payments were 11.5 million a year, probably double now. Total borrowings at 140 million. 97 million owed to banks, with site optimistically valued at 125 million. The application now to phase, to take the benefit of the 2020 permission without the burden of its obligations, was dealt with in unmistakable terms in pre-app advice of 26th of May. In the 7 weeks since the pre-app, the view that this was not phasing and not substantial has gone through a 180-degree turn. Building 4 is 125 square metres, and the whole development, for which permission is given, is 30,370 square metres. So Building 4 is less than 0.5% of the permitted development. It's hardly a phase, not substantial, and just a pimple on the scheme. Night-build heavy lorries moved in today, assuming it can start tomorrow. Should this application be granted, Building 4 will be the only part of current permission ever built. The building timetable for Phase 2 has no credibility. The current owners cannot bind the future owners as to what and when. So whilst the applicant wrote to planning, if we don't achieve this, all benefits will be lost for the borough and the site will be left undeveloped for the next 5 to 10 years. This will be terrible for us, terrible for the council, and even worse for the residents and local businesses of RBKC. This is nonsense. The benefits of an unimplementable scheme are nil, and the only advantage is to the applicant, its bankers, and the sale price. Under the applicant's ownership, the site has been left undeveloped for 8 years so far. Refusing this application will result in a more modest scheme being brought forward capable of implementation, which will be controlled by what will then be the current rules. The committee has plenty of evidence before it that this is no longer a viable scheme and should be put out of its misery. It's not the role of the committee to rescue the applicant and its bankers from the fiscal consequences of this overambitious, badly managed project. It's a false flag operation. The Section 73 application, which the committee does have power to grant, is merely a cover for an attempt to extend the life of the permission in perpetuity, which the committee does not have power to grant. Refusing it tonight would mean an end to the matter. The permission will lapse by Thursday, and no appeal on this Section 73 is possible, as that cannot revive the original permission to which it relates. Neither the Inspectorate nor the High Court hears academic appeals. Please end this and refuse it now.
Thank you. Where are we with this project? Sorry, a minute. Where are we with this project? It expires tomorrow. In 3 years, nothing has happened, and the project is uneconomic and unimplementable. The excuses given by the applicant are really not material. It's grossly uneconomic. There is no deal with TfL, and without it, the project is unimplementable. Any scheme without a raft will require a new consent. So 3 years on, with no progress, the applicant now proposes that this should establish permission in perpetuity. The applicant only raised the issue of phasing in the last 6 months. In pre-apps, they confessed they had no intention to execute this permission. The current consent falls outside the SPD and is contrary to the development plan as it is today. The developer has a poor track record. The development hasn't started, let alone have they completed any of the pre-commencement conditions. The current phasing proposal has been done at the last minute, and it's unacceptable to come at 1 minute to midnight, put a gun against your head, and expect you to roll over. So, what should the committee take into account? Well, the government advises that you look at the planning history of the site, the reasons why permission hasn't started, the time that's elapsed, and the prospects of successful delivery. Also, the circumstances have changed. You may all remember that Thomas's School is going to be on St Albans Grove, which is the main route to this site. And planning policy has changed in a way which would not permit this scheme. It is not in accord with the current development plan. The government is increasingly concerned about non-delivery and is proposing legislation to tackle it. So why are the residents worried? Well, they've had this hanging over their heads for nearly 5 years. There's no end in sight. It could be another 10 years. And there's huge uncertainty and worry in the community. Rather than extend the life of an unimplementable project in perpetuity, we urge you to go back to the drawing board. Refuse the phasing enables a new planning application, one that's sensible, deliverable, and allows a total rethink and can be realistic and policy compliant. We're asking you to do the right thing. Take back control. We urge you to refuse this application.
Okay, thank you very much indeed for that. I think, Mr. Cook, you'd registered to speak. It may be that in questions you will have the opportunity to answer questions as well. So if I can now move to the applicants who are represented by Savills this evening. In similar fashion, would you like to introduce yourselves and say how you'd like to do this?
Yeah, sure, thank you. So my name is Mary Fortune, I'm the agent for the application at Savills. To my left is my director, Simon Wallace, also from Savills. We've got a representative from Avison Young, the viability consultant, and we've got Dominic Gallagher from Knight Build, the contractors.
Okay, all right, very good. Well, in similar fashion, you've got up to 6 minutes when you're ready. Thank you.
Thank you, Chair. Firstly, I'd like to thank officers for their hard work and dedication to getting this application to Planning Committee tonight. We've worked positively and proactively with officers since January relating to the phasing of the consent, and we appreciate all their efforts. It's important to note that the Section 73 application involves no other changes, modifications or alterations to the scheme that was approved back at appeal in 2020. The application before you is a carefully considered amendment to essentially facilitate the scheme as approved, coming forward in 2 distinct phases of development. The first being the construction of the approved community hall, Building 4, with phase 2 being the construction of the remainder of the site as approved. The key issues since permission was granted have been the dramatic changes in the market resulting from the COVID pandemic and the extensive ongoing discussions between the applicant and TfL relating to the build-over agreement, which has taken longer than originally expected. The applicant has undertaken various extensive detailed feasibility testing and safety testing studies with TfL since the permission was granted, and these, to my understanding, have now been signed off, and heads of terms have been agreed with Transport for London relating to that build-over agreement deck. And that was done in January this year. This means there's greater confidence that the scheme, including the deck, will be brought forward. The permission, as approved, is a single phase of development that places extensive pre-commencement conditions, obligations, and a £9 million civil liability for a complex site. By phasing the development as proposed will ensure the scheme can be brought forward in a logical and efficient way that does not change the controls exercised within the consent, just the timing of when they are triggered. The phasing of development is common on larger developments. This is supported by national planning guidance, where local planning authorities and the applicant are in agreement. The principle of retrospectively phasing a permission is an accepted approach, as demonstrated by the examples we submitted with the application from Westminster and Enfield. A full updated viability assessment of the phased approach to the site has been undertaken in response to the planning inspector's comments on phasing and officers' comments during the application. The planning inspector said that phasing may not be problematic in itself at paragraph 141, but as the development is now proposed to be sequenced, viability needs to be reconsidered. This revised financial viability has been independently assessed by the Council's consultants Gerald Eve as well. The conclusions show that there has not been a significant change in the outcomes as a result of the phasing, but again, early and late stage review mechanisms are built into the legal agreement to capture any change in value in the future or unseen profit. Our viability consultant, Avison Young, are here tonight as well to answer any questions if required. The application also proposes changes to the wording of various conditions and definitions in the Section 106 agreement to align with the proposed phase approach. Details have been submitted pursuant to the proposed amended Phase 1 conditions and are all now agreed with officers as per the addendum committee report, so that if permission is given tonight, all pre-commencement requirements for Phase 1 are discharged and this part of the scheme can be brought forwards. The same controls as approved over construction traffic, demolition, construction management, amongst others, are still in place prior to the commencement of Phase 2 as set out in the committee report. The deed of variation related to this Section 73 application has also been agreed and signed by the applicant in advance of this committee meeting. The applicant has engaged with Nightbuild, a well-known and respected contractor in the borough for Phase 1, and I'm going to hand over now quickly to Dominic to run through some of the key management measures that will be in place during those works.
Thanks, Mary. I work for Nightbuild Limited, who have been appointed to carry out Phase 1 of this exciting development, subject to plan approval. As a chartered member of the Institute of Safety and Health and current chairman of ASUC, the Association of Special Underpinning Contractors, my best interests are to ensure that all works which we undertake are not only carried out to the highest of standards, but also to ensure that the safety of the workforce and that of the public is not compromised, and that all works are carried out with as little disruption and inconvenience as possible, all in line with the RBKC Code of Construction Practice. We're a professional company who've been carrying out this line of work for over 30 years in RBKC, Westminster, Camden and surrounding boroughs. We've our own in-house design teams, construction divisions, to aid us on our journey whilst undertaking such complex projects. In many ways, this is what makes us unique from others in the industry, and we're able to draw on our in-house skills and resources throughout all phases of a project, giving us more control over the final output. We also have a pre-construction department which I oversee, who are engaged in projects at a very early stage, such as the Haythorpe development, where we've been asked to help discharge planning conditions such as the Construction Environmental Management Plan, Site Environmental Management Plan and the Construction Traffic Management Plan. This enables us to gain a better insight into the key challenges of a project from the outset, and allows us to produce accurate documents, such as those mentioned, that can be replicated at site level so there are no nasty surprises awaiting the residents when the project commences. We're a Forest Gold accredited company, ensuring that all our own fleet and that of our supply chain are Forest approved, containing all the latest safety features together with competent drivers who have to maintain their professional development in line with the requirements of Forest. We're also a practicing clocks champion and one of only 5 companies in the UK who are approved to carry out clocks site access traffic marshal training, something which will be of the utmost importance to ensure the safe movement of vehicles to and from the Haythorpe development, especially via Southend. We own our own HGVs and our consolidation centre.
I'm sorry, time is more or less up, so Do you want to just conclude in a
Yeah.
sentence?
Whilst this may be seen as a challenging and complex project with logistical constraints, we do have experience of the surrounding area after carrying out works recently on a fantastic scheme in Southend.
Okay, thanks very much indeed. Thank you. Okay, so there will now be questions. So colleagues, who would like to go first with questions? Who'd like to? Councillor Lowry, Sina.
Hi. Firstly, thank you to both parties for coming and speaking and presenting to us today. I have 3 or 4 questions, Chairman. The first is, it's been obviously pointed out and mentioned that TfL agreement has to be put in place for commencement to take place and for the actual entire application to be executed. Has that happened? My understanding is that hasn't happened so far in the past 3 years. Is that correct? That's just my first.
So the heads of terms for the development agreement have been agreed between the applicant and TfL. That was done earlier this year. The next stage is the formal development agreement, which would come, because the deck's in phase 2, it's relevant to phase 2 of the works. So that would follow if permission is granted tonight, and that within the programme is supposed to take a further 12 months to agree and get signed between TfL, but that is part of the programme as it always has been. I mean, there's no extension to the programme just because of that agreement.
But that's like 95% of the programme. That's the bulk of it. And if you haven't been able to get an agreement in 3 years, what makes you think you're suddenly going to be able to do it?
I think the work that we've done within the 3 years is extensive. We have got much further forward than perhaps was at the point of when the original permission was consented. So there is greater confidence that that agreement will be reached. Obviously, as I've mentioned, the heads of terms are agreed, so that does give us greater confidence in the scheme and the debt coming forwards.
I'll just to be fair, I'll give residents an opportunity to comment on that issue if you wish to, before I go to my next question.
Sorry.
No, I was just giving you, to be fair, an opportunity to comment on the issue of TfL agreements, if you wish to.
If I may, we're told now that it was agreed in January, but in May, when the pre-app was given, Ms. Savaris commented on that they had no agreement at that stage with TLF. So I don't understand how she would have gained that from the applicants in May if there was an agreement in January. That doesn't make sense to me. There may be some agreement that if you pay us X, we will now consider it. But it was expressly said in the 2020 inquiry, they had to come in with a letter saying TLF had withdrawn its agreement. I'm sorry, but it just doesn't seem plausible to me that there's any agreement in January when it wasn't mentioned in May to the officer in charge of this.
I'd just like to comment that we don't have any evidence other than the say-so of the person here. And if there is substantial evidence, it should have been submitted. And it hasn't been. So why should we believe it when they're up against the wall to get a consent this evening? If it mattered that much, and it really should do, we should have been presented with it.
Do you have that tonight?
I don't have that tonight, no. However, I would say that if permission is granted tonight, that deck and the agreement with TfL would fall into the phase 2 part of the works. What we're considering here tonight is splitting the permission for phase 1. So I guess the development agreement isn't needed for phase 1. It's needed for phase 2.
How would you describe phase 1, which according to the application, is just the construction of one community hall in the grand scheme of things as an efficient phasing that will allow you to execute the whole development, which if you haven't been able to do that in 3 years, it's in a technical sense.
Well, there's no definition of how big a phase has to be. So phasing for all development will be bespoke and specific to that particular scheme. So this phase 1, yes, it's a small part, but it's independent. It can be done without any impact on phase 2. It involves a new building, so it's part and parcel of that development. It can be accessed and built out again independently. So it is a phase. It's the first phase of the development. I don't think it's important in terms of its size. It's clearly part of the development, and it's the first element that will be built in sequence.
That's not really what I asked, but I asked how the phasing, whereby it only constitutes one community hall, how does that make it efficient for you to execute the plans?
How does it make it efficient?
Well, how does this make it better for you to enable you to execute the entire plans, which haven't been able to be done in the past 3 years?
Well, it commences the development, for sure. The Planning Act actually states that a very small amount of work needs to be undertaken to implement a planning permission. So building a new building, the community hall would undoubtedly commence the development, and that will start with foundation works, and that would be sufficient under planning law to commence the development. So it's an act of work that starts the permission, and it's near the site entrance. It's really the first building you come to. So it's a logical way of starting the planning permission. Even though it's a small element, it's sufficient to commence.
Thank you. And to be fair, would the residents like to comment on that?
Sorry, I would. It is not logical in the scheme of things. As you saw from the pictures, it's a glass-sided building. Why would anybody start on a major development site with a glass-sided building? The point about it is that it's small, it's cheap to erect, and I agree with Savills. In technical terms, if you approved it, you could say it's commencement, but it's commencement only if you phase the building. But there is no logical building reason to put that there. They have a perfectly acceptable site office, which is what they say they will use it in the past, at number 10 Southend, and I know this because I used it as a site office. I rented it from them for 3 years, so they certainly don't need it as a site office, and it's not practical to use a glass-sided building or to put it at all on a development site. I mean, it's risible.
Could I just say that it is such a small part. It's like the tail wagging the dog, only this is a huge dog and a small tail. This little hall is the lever for allowing the whole thing to go ahead when we can see really no prospect. And when it came to the question of the deck, the letter that we have from TfL from January is not very... well, Joe's going to tell him.
The last letter on in public was from Graham Craig, Director of Commercial Development, TfL, to Johnny Sanderson. I paraphrase, I wanted to let you know the basis of our discussions, I now believe TfL have other prospects and can deliver a better return, particularly in terms of offering improvements to High Street Kensington Station. There are a range of other issues that previously prevented us from reaching an agreement. Notwithstanding those wider issues, I wanted to make you aware that we will not be seeking to reach an agreement with you on the development opportunity at High Street Kensington Heathrow. That is pretty clear, 20th of January 2020. That came up just during the planning inquiry. That's the last public document.
And if there was going to be something to prove that they could do it now,
Michael, I'm going to
there would
stop
be
you
a
there
letter.
because this is an opportunity for my colleagues and myself to ask questions, not for there to be a general discussion. Sina, did you have any more questions you would like to ask? Oh, okay. All right. Who'd like to go next? Gerard. Yeah.
There's a question really for the objectors. Listening to your arguments, it strikes me that it boils down to two arguments you're making. One is if we reject this tonight, it gives an opportunity to go back to basics and stuff, which of course is not really a consideration for us tonight as such. We are considering the planning application before us. But I can understand the eagerness of your argument in that. Can you just perhaps in a nutshell then, put that to one side and just in 3 or 4 bullet points, your objections to the phasing, not about whether it gives us a chance to go back and start the whole thing again, just purely the phasing which is before us tonight, just so I'm crystal clear on your objections to that. Thank you.
The objection to the phasing is that, I think as I've said, it's a false flag. It's not a desire to phase it, it's the desire to implement it. And as they have said, they've said in their, which Ms. Saveris has repeated, if they have an implemented permission, that will help them to sell it. It doesn't help to actually get the show on the road because we have no idea of what the eventual buyer will do with this project. So saying that if we phase it, then this will happen, they have no idea what will happen because they cannot control what the eventual buyer will do, and they don't have the money to do this. And I mean, clearly the company is not solvent, and they've been trying to sell it for a year, but it's not at the moment very desirable. So it's allowing a site to be sold with apparently a consent, and then you get these endless arguments, well, we've got consent for this, so let us build that. And if we argue, and we'll clearly be facing many other planning applications, so we think it should be with a clean slate.
If I can answer the question, this is just a device to get a consent in perpetuity. It does not guarantee delivery. And we have got this hanging over our head. We've had it for 5 years, and it's going to be a lot longer. We would like to clear the decks and get a sensible scheme. We're not against a scheme. This one relies on something that we don't believe will happen. And on the strength of this very small community hall, you're giving them the lever to have an indefinite consent. And we think that's wrong.
I just want to clarify the offer from TfL is you must have it to carry on even the phase 1. Am I correct in thinking that?
So I think there's been some confusion on dates. So 2020, be correct to say that there wasn't an agreement with TfL. January 2023, the heads of terms have been signed and there is agreement, but then there is technical detail matters to further work with TfL, and that will take another 12 months. But the heads of terms have been signed and are agreed, so that's a very different situation to January 2020.
So your agreement with TfL now and the starting of phase 1 will allow you to have the fuller agreement going forward with TfL. Am I correct in thinking so?
Yes, so the TfL agreement really relates to the second phase. That's when the deck would be built. And as you saw from the programme, that's a number of years away. And the technical details of this agreement will take another 12 months. But there is agreement there. The heads of terms are signed between TfL and the applicant.
to the objectors. I know you have a feeling they want the TfL, that they're not telling the truth, and maybe they just, I don't know, finessing it a little bit. I liked Gerard's question because he kind of he asked the question in clarifying the exact objections. From my understanding, you're objecting because do you not like the scheme, or you don't like the developer? It seems like there is because if they get permission tonight and sell, as you anticipated they will, so you will get rid of the developer. They might get a different developer. Is that your aim?
Absolutely not. The developer, I like the developers personally. I think it's just a shame they've got themselves into this mess. I don't like them enough to allow this scheme to go ahead without objecting to it. When you say that we think that they're not telling us the truth about the TLF, it's inconsistent. If they said in May to Ms. Savarus that they have no intention to build out the scheme, that's exactly, really clear in the pre-app advice, and that they have no agreement with TLF. Well, if you had however provisional, an agreement with TLF in January, why would you deny it in May?
Can I just answer that?
Yes, absolutely.
This would be, if such a document exists, crucial to the decision-making this evening. Why is it not on the record? There's one from January that Joe just ran out. Is that 2020?
January 2020.
Oh yes, beg your pardon. But this is such a critical document, if it exists, that they would appreciate how important it is for tonight's meeting to have that. And the fact that we haven't got it, and it's such a critical decision that's going to be made, I don't see how you can believe that this critical piece of evidence can't be here tonight to help make this decision.
Thank you.
Can I just quickly respond to that?
Yes, I think
Okay.
that would be fair, actually.
So,
and then
Thank
Roberta.
you. Thank you. Just while we were talking, the Heads of Terms agreement has been sent to me. I'm told it's under an NDA, so it's confidential, but the date is actually December last year. So I have got a copy of it on my phone.
Could you send it to us now?
No, I suspect not. But I think we should move on. Roberta.
Thank you, Mr. Chairman. Well, just quickly to say, I think we're sort of misleading ourselves by talking about a community hall here. It's a marketing suite until anything else happens. So there's not going to be any community benefit for that from that phase one until the rest is completed, from my understanding. But I'd just like to really to tap on to Councillor Hargreaves' question, because I don't think it was really explored fully, and just for the help of colleagues on the committee as well. The reasons why you're objecting are clear. But I guess to put Councillor Hargreaves' question more pointedly, if you were on the committee and you were voting against it, what planning grounds would you use, to be blunt? Because the issue, the fact that this grants it in perpetuity and then wouldn't give us a development ever, it just means that they have that permission is immaterial, unfortunately.
There's an inconsistency in planning law. The reason that you're given 3 years is so that there will not be an accumulation of unbuilt permissions. And then you have this other thing, which is if you've made a start, however small, this goes on forever. And it's then used to do other things. It's because it's completely unknown. The reason for you to refuse it is Section 73 is discretionary. It was refused by the inspector, and they waited another 2.5 years before they decided, well, this is the way we would like to do it. It has now been rushed through, which I really don't like. There's a mass of documents which we haven't seen, which are on the addendum, and when they have said they are not going to build out phase 2, how can you accept phase 1? I mean, their argument, they have destroyed their own plan. I mean, it's out of their mouth. We're not going to build phase 2, but you know, we have all these plans, and so let us have phase 1.
You ask?
Can I ask a question, actually? Briefly, Michael.
There is you have, just as the original decision and the inspector's decision had to be made in the context of the policy that existed at that time. Because you're instructed by law that you have to determine planning applications in accord with the development plan unless material considerations indicate otherwise. Well, what has changed is that the two development plans, the local plan and the London plan, and the inspector didn't have all of that to hand. He had the local plan, but not the London plan. And it's very clear now that extra care housing is housing, and that requires affordable housing to be an integral part of the package. This scheme has been developed purely as a housing, a high-income, high-value housing scheme without any affordable housing within it, other than the amount that required for the conversion of the townhouses on Kensington Square, which was quite right. But if this was being developed today, in today's policy climate, then it would have to be a different scheme. And you're being asked to assess it in relation to the policies as they exist today. So if you ask, do we not like this scheme? It's too big. It's unlikely to be developed and the fact that they've got to bring and build a raft as well as all the buildings is going to cause a lot of problems, which the inspector recognised. And okay, you've probably got the idea.
Thank you for that. I've actually got a follow-on question really from that. The inspector, right at the end of his report, the paragraph 141, which is actually quoted in some of the objection letters. And what the inspector seems to me to be saying here is that a phasing was put right at the end, a phasing suggestion was put right at the end of the public inquiry. And to my mind, the inspector doing precisely what you would expect a planning inspector to do said, well, I haven't actually heard any evidence about phasing at all. And on that basis, I'm not just going to grant it, you know, without having any evidence. Now, that seems to me to be rather different from the inspector saying there is some fundamental problem with a phasing of some sort coming forward. Would someone like to address that point? And then I've got one further question.
This was something that was put to him outside the inquiry, and his rejection of it, if you can call it that, was not on its merits, but in the fact that it was being done outside the inquiry and was therefore not subject to any scrutiny. So he couldn't agree to it, and it is no reflection on the merit or otherwise of the proposal.
No, I think, no, exactly. I think, yeah, we're agreeing with one another about that. I just wanted to put a point to the applicant's agents. I take the point that the proposed phase 1 is rather modest, and the phase 2 is the bulk of what is currently has been approved. in terms of actually implementing phase 2, presumably incredibly important to local residents conditions like a CTMP for phase 2, that would have to come forward presumably as a pre-commencement condition. Is that correct? Can you just confirm that? And also some of the other, I mean, for example, there's extensive demolition for some of the buildings later in phase 2. Can you just confirm that that is indeed the case?
Yes, that is the case. All the same conditions still apply. Controls over demolition, construction management, CTMP, Code of Construction Practice. The application simply just splits them to align with either being discharged under phase 1 or phase 2. So phase 2 will still have the same controls envisaged by the original appeal decision over those matters, pre-commencement.
Thank you. Any final questions that anyone would like to ask? Yeah. Okay. Well, thank you very much indeed, everyone who's spoken and answered our questions. We now move on to the next part of the meeting, which is the opportunity for members of the committee to ask officers questions. Who would like to go first, lead off on that? Waller, do you want to go first?
A couple of questions. One, I just want clarification that Section 106 has not been removed. It's intact and it's in place. It is just being divided into the 2 phases. Am I correct in thinking so?
Yes, that's correct. The Section 106 is not being swept away. What's happening is a deed of variation to make changes to it to reflect the proposed phasing, and the addendum report lists out what that agreed position is to allow those changes to happen.
And my second question is, have you had sight of that TfL contract letter? Can you tell us a little bit more about that? Do you know anything about it?
I haven't seen that letter from TfL. I've not been in any recent contact with the relevant people at TfL about this, but I'd say that whilst there's been a lot of focus in the questions about the development agreement, the bottom line for the council in respect of that is that the applicant and TfL enter into that development agreement prior to the occupation of phase 2. That is what the Section 106 agreement requires. So the applicant has given you an answer about the progress that they've made. I can't verify that, but I don't think it's required of me to do so, because the Section 106 sets out clearly what the expectation is, and that is, as I said, for TfL and the applicant to enter into a development agreement, and the restriction is on occupation.
Sorry. What happens if they don't get that agreement with TfL? In the fullness of time, what happens if that agreement doesn't happen?
My colleague Lorna might be able to advise you on that point, but as I said, the wording of the requirement is that there's a restriction on occupation of buildings. Lorna, is there anything further you could add to that?
Not really. I mean, the original Section 106 agreement just basically prohibited commencement until this, or rather occupation of various buildings, including the Building 4, until a development agreement had been entered into with TfL. But the Section 106 deed of variation is going to vary the original Section 106 agreement to allow the community hall, Building 4, to be built and occupied before the development agreement has to be entered into. So tonight, really, this is about introducing 2 phases, in making a development of 2 phases rather than a single phase. But the outcome of the Section 106 deed of variation is basically they can build the community hall, occupy it, without having to enter into the development agreement, which will only be required before commencement of phase, well, the rest, basically the other buildings, basically. So is that clear enough?
Just to be clear from your explanation, that means that they would have permission to go ahead with the 1%, but the 99%, as in the bulk of the development, which does sit in phase 2, cannot go ahead if they do not reach that agreement with TfL. That is what you're saying is the case. So the perpetual consent that we grant tonight would allow it to sit there should an agreement not be reached with TfL because phase 2, which comprises around 98-99% of the development, cannot actually be built. That's correct. That's basically what you've just said. I just wanted to confirm that's what you've said.
Yeah, basically, apart from the community hall, they wouldn't be able to occupy anything else apart from the affordable housing until they had entered into the development agreement. So they wouldn't, apart from occupying the community hall and the affordable housing, they wouldn't be able to do anything else, wouldn't be able to occupy anything else until that development agreement. So they can still build, but not occupy anything else.
One further question, Chairman. As mentioned in the presentation, if we grant permission for the phasing tonight, as you stated, this would be consent in perpetuity. What powers do we have as a council to rescind that should it become very evident that it's not possible to execute this development? Because if it's in perpetuity, that could raise some issues for us as a council to be able to actually deliver for our residents.
Yeah, the scenario that you've just described is something that we come across quite frequently. An applicant receives planning permission for a development. They may choose to implement it, and I should say the threshold for implementing a planning permission is very low. It has to constitute a material operation. That is a very low bar threshold. And then it is open to an applicant to choose not to proceed with the rest of the building out of that development to completion, if that's what they want to do, for whatever reason might be the cause behind that. So in the majority of instances, that's what happens. Some small element of works may take place on site, and then the rest of the site is not built out to completion. However, there is provision within the Town and Country Planning Act for the council to serve a completion notice. However, the use of it is very rare. I myself don't have experience of such a notice being served to require an applicant to complete a development that has been started. So there is a provision, but it's a rarely used one.
Thank you, Mr. Chairman. I'm afraid I've got 3 questions, but hopefully quite quick ones. Firstly, just on that point that we've been discussing there of Section 106 and SIL, I think it'd be helpful for us to know what are we waving away. So in terms of the SIL and the S106, that previously would have, that if we don't phase the development, that they would have to give pre-commencement. What essentially are we giving up in return for giving them permission in perpetuity?
So in terms of the controls on how the development is built out, the council do retain full control over that. So all of the concerns that you've seen in objections about impact on neighbouring living conditions, construction, traffic, principally those issues were raised. The uncertainty of a development proceeding for many, many years and the disruption and inconvenience that can be caused by that. Well, all of those impacts are controlled through the conditions. You mentioned SIL. I wouldn't describe it as the council giving up SIL, because the full SIL liability will be payable if and when the applicant moves through the stages of the proposed phasing. So on commencement of phase 1, there is a small SIL liability that the building of the community hall attracts. That's for the Mayor of London SIL rather than our own. And should the applicant proceed to phase 2 of the development, then that SIL liability would become payable at the start of that phase beginning. So the council would receive the money that is required to make the mitigation and necessary improvements from that part of the development phase.
Fine, but I think the point is we would, you know, if they don't get the phasing, we would be getting the money for them doing what they're proposing to do in phase one. So in a way, we are sort of giving it up. It's almost like until a future potential date. So I sort of feel like it's a bit of a dereliction on behalf of the local authority in terms of for the community. But the second query that I have is obviously, you know, I'm no legal expert, but Section 73 seems to be rather nebulous. We saw earlier this year with the Armstrong case where the planning inspectorate was ruled to have acted unlawfully in terms of, so it's not as if the inspectorate are God and know what they're doing the whole time, but they were ruled to have been unlawful when it comes to how they treated Section 73. And it seems very unusual to me, at least, that we have a situation here where, as officers say in the report, Section 73 applications cannot be used to extend the life of an application, but we have a Section 73 application that is here for the express purpose of making this application exist in perpetuity. I mean, it seems a sort of, you know, a contradiction in a way, really. And I was just wondering, I mean, this may be more for legal than for officers, but given, as I say, the slap on the wrist that both the inspectorate and the local authority had as a result of Armstrong, what the sort of position or understanding of that would be.
If I respond on the Section 73 point and the perpetuity and the time limits, as I said in my presentation, there is no mechanism to extend the time limit. So if the conclusion of the committee this evening was to grant permission, the date of expiry will match the one before. But what the effect of granting that permission does is, if I could put it in kind of informal terms, it changes the goalposts. So it makes it more practical for the applicant to be able to go on site and carry out enough works to constitute a material start on site. I don't think I'd describe it as a contradiction, but you clearly have identified that the mechanism that's being used does enable the planning permission to be implemented before its expiry, or rather it would, should the committee grant it.
No, I think that was a very good answer. It would enable the new planning permission to be implemented, but it's not extending the life of the original planning permission.
Great, thank you very much. And then just very, very quickly, finally on the point raised by Mr. Bach about planning policies being different. Obviously, when it was originally approved in 2018, there was, we were in a certain environment. 5 years down the line, we have a long list here of conditions, some of which you've changed, some of which you haven't. The two, very quickly, Mr. Chairman, that I'd want to touch on, the construction traffic management plan, which fine, in its majority relates to phase, will be put into phase 2, but even for this community hall, you're going to need, trucks and things coming down. We obviously now have the Thomas's application on St Albans Grove, and the situation there locally is very different to what it was 5 years ago. I mean, I would be concerned here that we're approving something, a CTMP, even if it is split into the two, that may have been appropriate then, but with all the applications going on now, might be less appropriate and should be reconsidered and looked at again. And secondly, just on the point of biodiversity and trees and landscaping, since 2018, we've declared a climate emergency. We care more about biodiversity. We have a bee superhighway. We have all sorts of green things. And policy is now coming in to ask for a biodiversity net gain. And I hate to always be the council's token tree hugger. But I feel, how come in that 5 years, we're now looking at Section 73, which is specifically about conditions, and yet we've changed all these conditions, but when it comes to trees, landscaping, and biodiversity, in that new world where we are asking developers to be more green and promote that agenda, and particularly in our march towards net zero, how come we've not asked for any improvements or anything more in terms of the conditions in that area? So just those sort of 2 points. Thank you.
Yeah, thank you. I'll take the policy point first, because, as you said, it was raised by one of the residents here. The appeal decision was made following an inquiry in February 2020. The appeal decision itself issued in August 2020. By that time, the council's local plan, dated 2019, was adopted, and that local plan from 2019 remains the relevant policy document which comprises the development plan. The update that's been made since the appeal decision was issued is the adoption of the London plan. So at the time of the inquiry, those London plan policies were draft policies, and since then, in 2021, the London plan has been adopted. This council is currently undertaking a new local plan review, which is ongoing, but those policies are not adopted, so they don't form part of the development plan at present. And as the report states at paragraph 5.2 and 5.3, those emerging policies are not being given significant weight in decision making. That will change as time goes on, but today, when you're considering this application, those policies are not being given significant weight. I think if I can then move on to your point about things like managing construction traffic and the changed circumstances since a point in time previously. That is actually the reason the conditions were imposed, because at the time of the inquiry, a draft CTMP was provided showing a methodology. And since that time, and for the purposes of this application, the applicant has prepared a CTMP as it relates to phase 1 only, and that was prepared in the last couple of months. So it does reflect the situation as it is on the ground today, taking into account neighbouring and nearby developments, including St Thomas's School. There is reference in the CTMP to that nearby construction site. What I would say is that any planning permission that is granted subject to a CTMP in the vicinity, it will be on the responsibilities of those individual sites to be monitoring any CTMPs that are approved by this council to make sure that they're not falling into breach of anything, because you can imagine the situation, a neighbouring site starts doing something and that causes either someone else's CTMP to not be workable. It will require all those relevant parties to reconsider whether their CTMP remains fit for purpose, and that is the way we are able to retain control over construction traffic through our roads. So yeah, in summary, the CTMP details for phase 1 do reflect the situation as it is now, rather than a position from a point in the past. And then I think you also asked about climate change, biodiversity. You're right, this council has made commitments, green commitments, they're important. But I'll bring you back to what the legislation enables us to consider under a Section 73 application, which is that we are only allowed to consider the question of the conditions that are subject to which planning permission should be granted. And so the conditions that have been identified as the ones needing to be varied, none of them relate explicitly to ecology or biodiversity, but I will say that there are conditions that have been varied in respect to trees, but there are no greater tree losses, for example, than what was previously permitted. It's simply about the phasing. I hope that answers all the points.
I've just got a couple of final questions. First of all, can I ask about phasing? Because clearly, the proposal is rather lopsided. Is there legislation, or it might be, planning policy practice guidance, if I may have got the name of that wrong, or other sort of formal documents that indicate criteria for phasing? Is there anything like that, or what's response to those sort of criticisms and comments that were made earlier on?
Phasing is really a matter of planning judgment. There is no set out wording that I could point you to in a policy document that says phasing shall be comprised of X, Y, Z. However, you would see in the committee report that the original application submission wasn't considered acceptable by officers, and part of that feedback to the applicant was that the scale of works the extent of works that were being put forward as phase 1 were not sufficient. And so the application has evolved to a point now where phase 1 comprises the construction of Building 4 Community Hall, the site access from South End, and the landscaped area to the side of the building. So it was in the planning judgment of officers that was sufficient to constitute a phase of development.
So in effect, officers actually have already taken on board some of the points that have been made this evening. The next point I wanted to ask about was, viability. I mean, clearly a consequence of phasing is that the SIL payments are also phased. That will have an impact on viability, surely, and that has all been considered, has it? That's been all put into the mix?
It has, and earlier on I heard reference to the planning inspector's decision, in particular paragraph 141, where at the close of the inquiry this issue of phasing was raised. And I just want to repeat some lines in paragraph 6.20 of my report, where the inspector says, whilst on its own this may not appear problematic, the GLA raised the pertinent point that this may have a collateral effect on the balance of values and viability assessments, and so could potentially materially affect outcomes. And so for that reason, the Section 73 application route has been chosen because it does allow for consideration of matters which are material, viability being one of them. And in the committee report, from paragraph 6.19 onwards, it sets out what has happened during the course of this application where viability information has been provided by the applicant. It's been reviewed on behalf of the council by Gerald Eve, and Gerald Eve's conclusions are set out in paragraph 6.37, and you'll see in paragraph 6.36 there is a table which provides a comparison of the planning permission scheme against this Section 73 application, which contains the phasing. And Gerald Eve's conclusion is that the Section 73 application scheme is more viable than the planning permission, but if you look at the table where the deficits are shown, still significantly in deficit, and therefore we've been able to conclude that in viability terms there are no further contributions towards affordable housing or any other matter that could be secured through this development.
Okay, thank you very much. Okay, Roberto, just a last final one.
Thank you, Mr. Chairman. Just very quickly, just to touch on your point of judgment, because essentially that's what we're going to have to then be deciding at the end of tonight. Could you talk us through, just because I'm conscious in the 5 years that I've sat on planning committees, I don't think I've dealt with a solely phasing application before. And we've heard from Councillor Lara's calculations that only phase 1 is only 1% of the entire application, if that. How has it changed from that pre-app that you said wasn't acceptable and you judged to not be sufficient to be? How has it made this, what was that, how small, infinitesimally small was that to be considered insufficient, but the 1% that's being proposed tonight is sufficient? I'd just like to understand your train of thought there so that we can consider it when making our judgments.
Yeah, certainly. I'm just trying to find the relevant part of the pre-application advice note. It is available on the public record, but the pre-app isn't really relevant to what you're considering now. But just by way of background information, the works that were proposed at that time were very low-level, kind of enabling works on site, but still sufficient to trip the threshold of being a material operation. And over time, through discussion, that grew to being the construction of a whole building, with Building 4 identified, because Building 4 would occupy an area of open space that exists on the site. There's no need for demolition. And further to that, through discussion, the applicant was advised that Building 4 in isolation wouldn't be sufficient to satisfy officers. We wanted to be reassured that it's not just the construction of a building, but the access to it and any landscaping around it that would enhance its use, because what we are concerned about is making sure that building is used. And so, given its description as a community facility, if it has unobstructed site access to it and the building is there and it's got some green landscaping around it, that could probably increase the range of activities that that facility could allow to happen, we were then satisfied that that would be sufficient to constitute a phase.
Okay, thank you very much. So I think we should just perhaps take stock, Colgis, where we are thinking about this. I mean, I think I'll start off. I think this evening, in many ways, it is a reminder that the actual structure of the planning system and the legislation that sits behind it can sometimes, I can see, seem really quite favourable to large-scale development. That the applicants are allowed to put in applications. This site could have another application very quickly. All kinds of matters could come forward. That would be entirely proper in terms of the way the planning system operates, to my mind. I think on the quite narrow issue in front of us, I think I hear what people say about the phase one being a modest development, but I think it is something that is sufficiently substantial to my mind for it to be acceptable. For phase two to come forward, a lot of incredibly important things would actually have to happen. In particular, from a resident perspective, all of the matters relating to demolition and construction traffic management, they would all have to come forward and be agreed. We've also heard the matters relating to TfL. I mean, that's highly confidential commercial matter, which I don't think we can reasonably expect anyone to discuss in public, but that would be necessary before phase two could actually be completed. I think the talk of something in perpetuity, I think the fact that there are all of these pre-commencement conditions for the proposed phase two, I think does offer protection, as I think officers have outlined. So because of the quite narrow planning issues in front of us, I think that on balance this is acceptable, but I'd like to be interested to kind of go down the table as to what colleagues, what you think about it. Who'd like to go? Sina, what would you like to?
Thank you, Chairman, and I do understand a lot of what you're saying here, but I come back to the point made by officers that phasing is a matter of judgment, and we are dealing with just the phasing here tonight. There are material considerations relating to this, which I think bring my mind to a slightly different conclusion. Government policy has changed. The government, the Secretary of State, has been very clear about tackling non-deliverability. Our borough itself has had a huge issue with non-deliverability. There are plenty of schemes much grander than this we can even mention, where non-deliverability has affected our ability to provide housing, community services, etc. And there is not enough information given to us tonight which can support, which is evidence to support that this is a deliverable project. That's just a fact. Prospects for successful delivery are practically non-existent from what I've gathered. Another separate issue I have with this application is the perpetuity. It's been confirmed that if we give a yes vote tonight, that's perpetual consent. And that presents, I think, huge issues for us as a borough. For our residents who will be affected by the blight of an undeveloped site for ages, That's exactly what sort of the new local plan which our leadership team presented, the new London plan which exists, also intended to tackle. It is correct to say that when we take into account the London plan, which is law, and our leadership team's local plan, this application, what's presented in phase 2, would not actually be allowed. They'd have to come back with a fresh application. And I think those are 2 points which we have to bear in mind. And for those material reasons, I don't think, I'm not convinced about the implementability of this plan, and I don't support the officer's recommendation, therefore.
Okay. Well,
I'm going to pick up where Sina left off, and it's the challenge here. I can see the emotions and the feelings and the desires of the residents, and maybe some members on this committee, but what's in front of me is actually a very clear, offer. It is about the phasing. I am sitting here on this committee to decide on that particular issue and that particular issue only, not what might happen, what could happen, what hasn't potentially happened and maybe is happening behind the scenes. I have to be very pragmatic and look at what's in front of me and decide on that.
okay. So if I've understood, you're sort of minded to go along with the recommendation, but obviously we've all heard the points that have been made, and we all understand them. Who'd like to go next?
Planning is always so interesting, Mr. Chairman, because we all see the same facts and come to such different conclusions. My view would be, I think, building on I guess, what Councillor Ridge said, I look at this phasing and what the officer said about judgment, and just think that what we've got here, as Councillor Lowry said as well, that we're granting something in perpetuity when they've had 3 years. We're not getting anything from, as was said about CLNS 106, fine, in theory it's still there, but you're granting an application that had all these conditions added to it when it was granted originally because they were felt to be important. We're pushing them all back, saying, just to keep this alive, we're waiving our right for now to CLNS 106, which are all imposed to try and make the balance of benefits even and make the development a benefit to the community. And so I just feel that the application, when it comes to the phasing itself, is not, despite what officers have said, is not, regardless of the viability of the wider scheme. I think in a way I find it very uncomfortable actually, the dubiousness of which, fine, as we say, some lawyers might think is acceptable, that we're granting something on the basis of an application being Section 73 that specifically says you can't amend the implementation date by, but we're granting it to get past that. I mean, to me, it just seems, I would be surprised if it held up in a court of law, to be honest.
Thank you very much, Mr. Chairman. This is one of those applications, isn't it, where we are grappling with the application that's in front of us in its purity and all the issues around it. Is the putting up the glass building sufficient? I don't know, that's a judgment, but it meets the law, it meets the regulations. The question of perpetuity, yes, there is a danger of that, but actually that's part of what this is all about. So one feels many things about an application like this, but at the end of the day, I'm having to make a judgment on this application, not many of the other things that surround it. And those are judgment issues, the things that surround it. So on what's in front of me tonight, whether I'm feel good about the whole thing or not, I think I'm minded to actually say we can, on what's here, we grant it.
I'm going to ask Lisa Chung if you've got any sort of last comments, and then I think I've got a fairly clear idea of where we're heading on this, if there's anything you wanted to add, and then I think we probably move to a vote.
No, I don't. I think it's all been covered rather succinctly by Cheryl and others. Thank you.
Yeah. Ms. Chung actually said she didn't really have anything to add. Sorry, that was it. Okay, well, in that case, the recommendation in the officer's report is to grant permission and also noting the deed of variation. So if I can see those in favour of the recommendation, please. So that's Councillor Idris, Councillor Hargreaves and myself. Can I see those against, please? That's Councillor Whedon-Sands and Councillor Lowry. So that is agreed by 3 votes to 2. Thank you very much indeed, everyone. Thank you indeed for coming.